The steering committee is called to order. At this time, I'll call on Vice Chair Brad Turner for the reading and approval of the minutes.
Mr. Chairman, I've had a chance to review the minutes, find them in order, and I make a motion for their approval.
Okay, we have a motion. Is there a second?
Second.
All in favor, please say aye.
Aye.
Motion passes. First item on our agenda is to fill a vacancy on the Emergency Communication District Board. We have one vacancy and one applicant, Mr. John Hood. Notice Mr. Hood is in the audience. Would you like to address the committee? Or
Well, it's been my pleasure
say
to serve on the commission since it was initiated when we first had the referendum, and I enjoyed being treasurer, and I appreciate the opportunity to continue to serve. Thank you.
Mr. Chairman, I move that nominations cease and Mr. Hood be elected by acclamation.
Is there a second? All in favor, please say aye.
Aye.
Motion passes. Thank you so much.
Thank you very much.
At this time, we will announce 3 vacancies on the Community Care Board. We will also announce 6 vacancies on the Board of Health. And at this time, we have a resolution regarding a property tax matter for the historical home pursuant to Law 67-5218. And Mr. Josh McCrary is in the audience. Oh, there you are.
I'm here.
If you'd like to address the committee.
Thank you all. Rearranged here.
Yeah. Didn't want to get
It's
too comfortable.
confusing, yeah. Okay, so at the last meeting, I understand that you all discussed this historic property tax exemption and the statute. There were some questions about how it would apply, and so the mayor and I spoke about those issues. And I looked at several things, and I think the mayor sent a few items to you that I hope are on your iPad. But I'll summarize a few items here, and kind of in what may ultimately be ascending order of importance. I think the last thing I say may be the most important part, but I understand there was initially a question about if you do this, would the reduction or the exemption apply to the entire structure or to the improvement portion only? So I looked around and I could not find any real authority one way or the other for whether it would apply to the entire structure or only to the improvement made or the restoration made to the particular property in question. My opinion, based on the statute alone, is that it would apply to the improvement made or the restoration of the structure. And I say that just based solely on the language in the statute, because it says the value of any improvement made or to restoration of any structure, which implies to me that I guess the way you do that is you take the value of the structure pre-restoration or improvement, compare it to the value post-restoration and improvement, and you would get the reduction based on that improved portion. Now, that's an interpretation of that language. So there, I can see there might be more than one interpretation of that language, but I think that's what that language means based on the totality of the language in the statute, which implies that a homeowner who's got a historic property comes in and uses the word agreement in the statute. So there seems to be some scenario where there's an agreement to improve the historic property, which would control what improvements are being made and so forth, and so would apply only to that improved area, I think. I noticed in here, and I'll mention this almost in passing, it talks about the board and how the board would be appointed, and it uses the term chief administrative officer in the statute as to who would appoint the review board, subject to the legislative body's approval. So at first read, I think we would all probably read that to mean the mayor, but I did park on that just a little bit because the actual language under the county mayor statutes uses the term chief executive officer, whereas this statute used chief administrative officer, which could create, I mean, at least arguably some question about who this means. I think it probably means the mayor when you read it through, because I don't know who the chief administrative officer is. If it meant the assessor, I would think it would say the assessor, because that's a recognized term. And that phrasing, chief administrative officer, is not language I've seen in other statutes. So I suspect it means chief executive officer, which would be the mayor, who would nominate the board subject to the county commission approval. All right, and then the last thing, and again, this I think is the most important, and that is there are some AG opinions that I think seriously call into question whether or not this is even a constitutional statute. So again, not knowing with certainty which Attorney General opinions you have in front of you, but there are basically three that kind of track one after the other. The most important one's a 1977 one that is based literally on the predecessor statute to this one. And it says in there, citing the Tennessee Constitution, that first of all property in Tennessee is subject to taxation unless there is a valid exemption. And then under the Constitution, those exemptions are only for religious, charitable, scientific, literary, or educational purposes. And so the Attorney General's office goes on to say historic is not one of those. It's not purely religious, charitable, scientific, literary, or educational. Now, again, arguably, it could be both. You could have I assume you could have a historic property that also serves an educational purpose. But I think the point that the Attorney General's office is making is that that's a leap. I mean, it doesn't necessarily follow that just because something is historical, that it meets one of these other categories: religious, charitable, scientific, literary, or educational. And if it does not, then it would not be a constitutional reduction in tax, according to the Attorney General's office and their view in 1977. They looked at that two other times. The statute that we're talking about was amended in 1980, and there was an AG's opinion in 1982 where they looked at it again. And they seem to say in that opinion, if you have it in front of you, they seem to say, well, it could be that this amendment makes it technically constitutional, but only if the property would otherwise qualify as exempt for one of these recognized categories. So that is, again, religious, charitable, scientific, or educational. So I don't read that opinion to mean, okay, now it's fine, everything's constitutional. I read it to mean, hey, we already said before it's unconstitutional. We think it still is, but it may be that if it qualifies for one of these categories and it's historical, that it might be okay, but if the property in question would answer that, and we don't know the property in question, so our old opinion still stands, that it looks to me like. Then they look at it again in another situation in 1998, dealing with the city of Jackson, and they look back to these same old opinions, where they state the same basic premise, which is unless the property is for one of those categories, then a tax exemption, in their view, isn't legal. So, with that, as you know, Attorney General's opinions are just that, they're just opinions. And I could not find a court case that says it is unconstitutional, or that applies it, says it in application it's unconstitutional. So these are all just AG's opinions. I do notice that the AG does cite a case or two in its opinions, okay, but not specific to this statute, more generalized around the concept of which categories of properties could be tax exempt. So anyway, with all of that, if we look solely at those AG's opinions, it certainly may be that if we adopt a resolution that puts into effect in our county what the statute appears to allow, if it gets challenged, we may not win. So I think that answers the questions that were raised, and maybe one that wasn't raised. But I'm happy to try to answer any questions that I can.
So the law says we can do it, but an elementary student reading the Constitution would clearly state that the law is unconstitutional.
Yep. Well, I don't know about an elementary student.
Well, if you look at it, I
I
mean,
get the
it's plain
get the
language.
premise.
Very plain language, unless it reads a way that other than you read it.
I understand. You have to assume that a historic property would also be used for educational purposes or for one of these other recognized purposes. And again, it may be, we have historic properties that are used for these other purposes, but not all. Some people just live in it.
But the whole property wouldn't be tax exempt, just the improvements.
I think that's right.
Just out of curiosity, Josh, who defines that the religious, charitable, scientific, literary, or educational? Is that to your point earlier,
Yeah.
You might have a historical society that meets there once every year.
Right.
Does that qualify or does it not? And if it doesn't, how is that defined inside there about being educational for their purposes or charitable or religious or whatever? Right? Just out of curiosity.
Yeah, well, there's going to be, there would be several ways that I think that could happen. One would be that they can apply, any sort of exempt property could apply for an exemption. And so the assessor's office initially, churches do it all the time.
Sure.
They say we're a church, and so they look at it and determine whether or not it is. But in terms of broader definitions, you would find those in several places. There probably are some where there have been challenges to real estate taxes in the court system where some property maybe has been challenged as whether or not it is actually religious or whatever. And I can remember a really good example of this, and I'm maybe on a little bit of a tangent, but maybe not. I remember several years ago, Christ Church on Old Hickory Boulevard in Nashville, they spun out a YMCA. They had like a workout center. And the assessor in Davidson County went in and determined that that portion of property that they were using for the workout center was not religious. And there was a big war. I read about it in the paper. It went on for a long time about how that would play itself out. And that's when if you drive down there now, there's a YMCA. YMCA took over the workout center as a workaround situation, I think, from that problem. But the point I'm making is there are instances where someone claims something like a religious exemption and then they're critiqued on whether or not they qualify. I know across the country, a lot of the larger mega churches will have a coffee shop or a bookstore, and I know in some parts of the country, maybe less so here, but they'll look at those and say, well, that part's not really religious. We're going to tax you full freight on that part. So I think in the first instance, that's where it would get critiqued. In the broader context, there are also IRS regulations, and because the same principles apply for 501c3s, so there is some guidance there in terms of what that means. I don't know, we can't resolve it here because it would be on a case-by-case basis,
Sure.
but I do think there is some guidance out there that could be applied to specific instances.
Yeah, that's kind of what I was looking for. To your earlier point, if it's, at what point do we move forward if the Attorney General keeps saying, well, we're not sure
Right.
this would stand up in court. And we've got a lot of, areas around here that in theory fall under, the educational, a Civil War battle happened there or within proximity of the house or something like that. That seems to be educational, but, who's to say Josh thinks it's educational? I don't. I just was curious, but I think to Commissioner Gooch's point that, if the Attorney General keeps saying you might not want to do this, it's a pretty strong exercise in caution.
It seems risky.
Yeah.
Is there any other counties or incorporated cities that have adopted this?
I don't know the answer to that. Do you,
None.
Mayor? I haven't looked at that.
there for a while, you had to be at least 200,000. They changed that in some year. You can be,
Right.
any county
Yeah.
can do it now, but we're not aware of, I'm not aware of any other counties that are doing it. Not to say there aren't some though.
The thing is, if it did qualify for one of the other categories, then it really wouldn't need the historic
It's already
tag
tax exempt.
anyway. It would already qualify under the general law. So we'd be adding a category, but we wouldn't actually be adding anything. I don't think.
Follow your scenario through a little bit.
Mhm.
If we adopted this,
Mhm.
and we had applicants, and they were approved by this board
Right.
as a historical reconstruction and resurrection, if you please, and somehow, some way, somebody decided to file suit,
Right.
and we lost that suit, what would happen not only to us as a county, but to that property owner at that particular point in time, Josh?
Well, I don't know that anything would really happen to the county at that point in time. We would have uncollected taxes, and we would be in a position, I think, of trying to figure out how to collect those taxes. Now, anytime you have an unconstitutional policy, it can wreak some havoc, because you might actually have somebody who benefited from that tax break who then winds up suing us for having like, suppose somebody says, well, I wouldn't have bought that old dilapidated house but for the tax advantage. Now I've gone out and bought it, and I bought a bag of problems with this house, and I've put a bunch of money in it, and now I don't have the tax exemption. So now I'm going to sue the county for having relied on it. So, it's anytime you have a policy in place that is facially unconstitutional, I think not only might we be challenged just from some taxpayer, I guess. Of course, you got to have standing to sue, and so there's a whole separate issue there. But you might have just Joe taxpayer who says that's not fair and it's unconstitutional challenge. But you also might even have somebody who applies for it, and if it's later found to be unconstitutional, then they sue for having relied upon an unconstitutional policy. So it's also possible you put it in place and no one ever asks, and it's never an issue. I don't know.
Would it be futile for us to send this proposed policy to the Attorney General now and ask for an opinion? Is it constitutional according to the state of Tennessee?
You could do it. I think it's, I don't know what they would say. I guess it seems more likely than not they would cite their prior rulings and say, well, we've already answered this. But they might not. Time, things change and time passes and you get different people. So I suppose that's possible.
Last month, excuse me for
Sure.
getting on my soapbox, but last month I had some devil's advocate questions that related to this, and thinking this thing through over the last couple of weeks, I see a number of people in here who are native to the county and have never lived anyplace else. I'm one of them. And it's hard for me to recognize where our county is versus where it's been. And preservation of some of these properties is important to me. And I'd like for us to be able to do it if it's legal for us to do it.
Yeah.
But like other things that we've approached in the past, regardless of how we feel about them personally, we're obligated, in my opinion, to do the right and legal thing for the county. But just thinking back as it relates to some very, very old friends that I went to high school with and has come back for high school reunions. Matter of fact, last year, my 50th reunion, high school reunion, they can't recognize the county, just can't do it. And that's to me just extremely important that some of our heritage and culture is preserved in some way, shape, form, or fashion. And I'd really like to see us to be able to do this somehow, some way, if we possibly could. Any suggestions as it relates to how this could possibly be done in a legal way.
Well, I do think if it's important to you, that maybe trying to get another Attorney General's opinion may be the way forward, and then you know we're not guessing, well, we're still guessing, it's still an opinion, but it's more of an informed opinion instead of trying to reason by analogy. The one thing I wonder is, in many of these instances, and kind of to your question and point, I don't know how much the historic property has to also be used for some educational purpose to somehow make it legitimate. And that may be, if you wind up posing questions to the Attorney General's office, that may be a line of questioning that you could ask among the questions, and that is, what if you had a person who lived there, and it was a historic house, but I don't know, what would they have to do to also be using it for some kind of educational purpose? And I don't know the answer to that. I mean, if there's a historic walking map and it's identified, and you walk down Main Street and it's identified on there, is that enough? It's educational at some level. Is that enough to make it educational? I don't know exactly where that line is, but that might be a way to get to a spot where you have a better, there's more of a comfort level with it.
I don't know how many of you have heard of Edzard County, and the other side of Atlanta and this side of Augusta, down in Georgia, called Washington County, and then the capital of that county is called Washington City itself, and it's historical. Just within 2 blocks of that area, there's nothing but historical homes with historical plaques, and it's my understanding that they are under some tax exemption type of status. Maybe it's just because of those plaques and the walking tour that you mentioned. I'm in favor of at least pursuing something like that and asking for the Attorney General's opinion, and I'll put that in form of a motion if you're willing to accept one.
Well, let me ask a question first, because I provide a little insight. But correct me if I'm wrong, we have a policy where certain senior citizens who are at a certain income level, their property taxes are frozen.
There is a process like that.
Okay, how come that's not unconstitutional?
I don't know.
Because it's frozen.
Yeah.
They're still paying property tax.
I mean, that may be the
So
distinction.
is this
It's not
not
exempt.
Is this not the same thing, that we're basically freezing the property tax? We're not exempting the property owner from paying taxes, but it's kind of like a frozen type situation.
But in that instance, didn't they define what the income would need to be? And I think that's what we would
there's a
try to
whole-
be asking, would be what defines historical, what defines the other 5 things. And because I'm with Commissioner Phillips, just for me, I think all of it's important, as Jeff said, for him to be a native of Rutherford County. But,
Yeah.
I enjoy history and the Civil War, and I'm very concerned about losing all of that, not just here, but across the country. And if there's a way to get an opinion that at least gives us a more concrete direction instead of, well, we think it might be this, but give us an updated version of, well, we're not sure if we would do that. I would second your motion if we move that into that talking space.
Okay, well, we have a motion and a second.
Second, yeah.
But going back to my question is, the law here provides for a board to set that standard, just like, I guess, the law provided the standard
Mhm.
for the income qualifications. And I would like to see this go through too.
Mhm.
And I guess my concern is if we ask for an Attorney General opinion and they come back another negative, but we can justify it's more of a property tax freeze, then some, might be less likely to vote for it if we have that opinion.
Mhm.
So what is the thought of us just maybe not doing the opinion, and we can rationale that it's a freeze, which is legal, obviously, under the Constitution, and just move forward?
I don't think that's a wise approach, actually.
I'm just asking for,
First of all, this statute is very specific. It doesn't give any leniency or try to even define what is a real exemption purpose. It only limits the age of a historic property to be included here. So you're going to have to, what you're discussing is asking the Attorney General a set of what ifs. What if this property was used for a religious or educational? If it is, they've already said yes. You can, it's already subject to being exempt. So you've already got that answer. Now what we're trying to find out is if it's not used for one of those purposes, period, can it be tax exempt on these improvements? That's all you've got that you can continue to ask. Now this business about whether this freeze is the same as this right here, just not allowing any taxation on this, not a part of it. I think probably they've already opined somewhere along the way on this tax freeze business. It's probably already out there. Maybe we ought to see if we can recover that and see what they said and how they made that determination, and see if it has any application.
That's what I was getting at, Mayor, was some definition behind it, because, you know, let's say Commissioner Stevens has a house that falls under this, and he has a Bible study there, or used to have a Bible study there with the first mayor of, you know, Murfreesboro or something like that. Does that qualify as a religious, historical?
Well, I think it goes back to
that built, you know, the Southern Baptist denomination or something. I don't know how that gets defined, where Commissioner Stevens could argue that and say, well, it was, you know, historic because
well,
it
if
is.
it's got a 501c3 and it's nonprofit, and this nonprofit organization owns that house and it's used for that specific purpose, by Internal Revenue Code, it's already tax exempt.
Yeah, well, I guess maybe religious isn't the right one. And what was one of the other ones, Josh, that might be educational? So if they have a private school that comes there once a quarter, is that education because they're learning about the Civil War? Or
That would still be tax exempt under the usage. Can I speak briefly?
Yes.
Sure.
The legislative intent here is to encourage the use of private capital in the preservation of historic properties, independent of educational or religious or medical.
Mm-hmm.
And it provides for a committee, commission, whatever you want to call it, to define very specifically what criteria it would be. And then that's going to come back before the commission. And I can't see any reason, I can't see any downside to giving it a try. If it turns out it's impossible to define a historic purpose that justifies preservation, or a historic architecture has nothing to do with purpose, you know, would that be qualified? I would encourage you to go ahead and let's move forward. Let's attempt to define what would be the procedures involved and what would be the criteria to qualify the property. And it goes a step further. I think we need to also have a procedure to qualify the intended restoration or rebuilding or whatever.
For the house.
So, you know, putting in a septic tank is not necessarily going to be a preservation. There's quite a bit that needs to be done. But clearly the legislature is trying to find a way to get private capital into historic preservation. And we're not exempting from taxation. As you say, it's frozen, but we're still getting the tax we would have gotten if we had not provided the incentive and gotten some private capital involved. So, you know, let's give it a try. There's no downside at this point.
Well, respectfully, I disagree with what you just said there. This review board, there's nothing in here to indicate they're going to determine if it's being used for a tax exempt purpose. It's only to determine if this renovation and restoration is suitable and appropriate and
As a historical preservation.
For the historical preservation. That's all that's about. And I think there is substantial risk here until we determine if this has some reasonable chance of standing the test of a court case. Whatever it is, we're going to have to defend that court case. And even the cost of that, and if we lose the court case, of course, somebody's going to have to try to collect the taxes, et cetera. So I think we need more information before we actually do this. I'd just love to see if anybody else has done it yet. If they have, maybe they have not even been tested, but that's still another thing. I think we're at substantial risk here as far as county responsibility and taxpayer money, even though I love to do it.
So what does the Constitution, can you read, do you have the, what does the Constitution say?
Well, I don't have the actual Constitution in front of me, but I do have the site, I mean, the language out of it. cited out of a case in terms of what is exempt. That's your question, right? What categories are exempt? Is that your question?
Well, I just specifically, what does the Constitution say as far as exempt? Is it, you're saying that?
Yeah, the exempt categories are, and this is a quote, religious, charitable, scientific, literary, or educational. Those are the categories.
Is that the same thing as frozen?
Well, I think that's a good question. To be honest with you, I didn't really think about that when I was reading. I mean, you raise a good point. Would it be different if you said the historic portion still is paying taxes at the dilapidated value and they're frozen at that, so it's not actually exempt. It's just frozen. I mean, it's a linguistic thing, but I guess I don't know with certainty whether that would matter. I know what the AG said about this statute, and they didn't go down that road. They just said the statute's got problems because it purports to create an exemption based on a category that the Tennessee Constitution doesn't recognize. So if we do that, you know, I mean, it's hard for me in my seat to recommend that you do that in the face of these AG opinions. So if you do it, but you know, I mean, you're reading the same stuff I'm reading, so you know what the risks are of going down that road. The one other thing I could think of that you could do is, you know, the statute authorizes the creation of the board, and the board creates then the policies that he's speaking of, not really you, in my opinion, it's the board. So I guess one thing you could do, and I'm not advocating this, I should have just shut up, but you might be able to create the board, let the board develop the policies, and then if you wanted an AG's opinion, maybe you send those policies up for an opinion. Say, these are the developed policies that the board has created under the statute, and that's what you're trying to get AG reaction to. That may be a way forward too.
But just reading the pure language out of the Constitution, which Josh has cited here, where it says, it states in part that all real property is subject to taxation except such as may be held by the state, counties, cities, or towns, and such as may be held and used for purposes purely religious, charitable, scientific, literary, or educational. There's no other property that can be used for anything except that in its entirety.
It specifically said exempt though, didn't it, Mayor?
All real property is subject to taxation,
Right.
whatever that means, except such as may be held by state, county, cities, etc., and used for purposes purely religious, charitable, scientific, literary, or educational.
Theoretically, the property would continue to be taxed though, right? Under our proposal. And that's the reason that I'm saying, let's just go ahead and get an opinion now. Let's just do it. Let's just keep moving this ball forward and see what happens there. If there's a way to do it, and you know, I think no matter where you fit in government across the state, there's going to be a lot of folks that would be interested in preserving some of our historical sites.
Well, can you add to your motion to ask the Attorney General, is an exemption and a freeze different? Because we're already freezing people's property taxes based on other criteria than what the Constitution says.
I put 150% confidence in Josh many times in the past, and that confidence in his ability to ask those questions is unwavering. So, Josh, I would assume that you would ask those types of questions with the Attorney General.
Who can request an Attorney General opinion?
Well, I can't in my own capacity.
It has to be a
It has to go
legislative.
to-
You have to get one of your
We have to
state
get-
legislative
We can develop
members to do that.
questions and give it to them and ask them to ask the question.
Well, I think the main question is just whether a freeze and an exemption are different. If we can move forward with this, if it's considered a freeze versus an exemption. If they come back and say, no, it won't work, then
And maybe, I think this likely must have come up, so we can ask for the exemption, and even previous to that, we'll see if there's anything out there that addresses when they passed this last legislation, which has been in recent years, was an Attorney General's opinion issued, or was that question answered about the freeze? Did that violate the Constitution?
Yes, I've always heard that any law that they pass is a good one until it gets tried in court and turned down.
That's right.
My opinion on this is I haven't heard where any of them have been turned down. And I don't really want to be the stepchild to put it out there in the test case or whatever you want to call it. So, you know, maybe the route Jeff's suggesting, getting an opinion and also asking about the freeze, you know, may be the best route to go. Instead of, or maybe, Mayor, you may have already done the research.
No, we haven't done the research on an opinion on the freeze, of how that is.
Well, I don't mean that, but have any other counties, cities, municipalities, or whatever done this anywhere in the state?
I don't know unless
My
ours has
understanding, no.
C-test, it hasn't
We
been.
got people in the audience saying, no, it hasn't.
No.
You know,
Has not been done?
Has not been done.
Okay.
I'm gonna have Becky read the motion, and see what we got going on.
Pursue an AG opinion and include the question regarding a freeze versus an exemption if they are different.
Can we have a second?
Do we need to add in there, Josh, getting definition of those 5 things, or does it matter at this point? Is the key thing, like Commissioner Stevens said, about freeze versus exemption?
Well, I think that we may want to ask the question in a couple of different ways.
Okay.
I mean, I'm kind of construing that motion maybe to give me in consultation with the mayor.
Yeah, that works.
leeway
Yeah, that's
on how
fine.
we-
I just want to make sure everybody here
how
felt
we
all of those
ask it.
covered.
But it has to
But I
come
know
from the
this
full
issue-
commission, you just can't initiate it, right? Is that what you said?
I'm saying I can't, one of our legislators has to actually ask the question.
Okay, so the county
I
commission.
mean, I think the
has-
way we've done that in the past is I would coordinate with the mayor. We'll have to communicate with one of the legislators
Well, the DA can also do it.
and have them
Okay.
ask the question for us.
So if this committee passes that, we can move forward and need to go to the full commission.
I think we can go
I
forward
think
without
we
going to
can,
full.
yeah, I don't think you
Okay.
have to have it passed through the full
Okay,
commission to
cool.
make the request. As long as one of the legislators will pick it up and ask it.
Do we need to specify which one that might be?
I don't think so. Do you know differently?
I don't know different, I think whoever you think.
Leave it open.
Yeah.
It might turn us down if we have,
I've
Well,
got,
there's new ones coming.
yeah.
I've got one particular in mind.
Who's that?
That just won a primary this past week to serve as the head of this county, our state senator.
Okay, well, I'm sure you'll find one. Okay, any other discussion?
So the motion is just for that one question, or did it say any?
Includes. I just said pursue an AG opinion and include the question regarding freeze and exemption if they're different.
Can we say like, or any other questions the county attorney deems relevant?
I mean, he's going to,
I
it's
think
pretty
it's
open,
okay,
just
yeah.
make sure you include that one.
Okay, if there's no further debate, all in favor, please say aye.
Aye.
Opposed? Motion passes. Thank you so much.
Thank you, Josh.
Thanks, Josh.
Thank you, Josh. Also, on the iPad, you should see a list of our litigations. Are there any questions on that while Josh is here?
Just wanted to make a comment that saw a lot of those put to bed. I wanted to say thank you.
My pleasure. We're working hard at making the recently resolved list as long as we can.
What number are we down to, Josh?
There's still a number of pending cases, because there's always new things happening, but the trend is favorable, so that's good.
Quite a few years ago, when I was first on steering, I'd asked for a list. And when I got it, it was well over 100 cases that were out there then, well over 100. And they didn't close very quickly.
Thank you.
And we're nowhere near that now, just so people
No, we're
know.
not.
Any other business? If not, this meeting stands adjourned. Thank you.